Hi, I'm Teresa Ryan, and I am an estate planning attorney. I am an author, and I am also, at this point, an 11-year triple negative breast cancer survivor. And I am here today to talk to you about the conversations people don't want to have. Trying to get there we go. The conversation you can't avoid, discussion of medical directives and estate planning. And although this is a discussion of legal documents, it's important to think of this as a discussion beyond that. It's a discussion of your values and the things you care about, and it's a way of leaving directions to those you love and your healthcare providers, who you may or may not love, on what you would like and what's important to you. And so these are documents actually that everybody over the age of 18 should have in place, with the exception of one, and we'll get to that one. Everybody over the age of 18 really needs these in place because, as anybody who's been diagnosed with cancer knows, we never know what life is going to throw at us. So what I'd like to do today is walk you through these documents, show you what they look like, what you should think about, and kind of how to fill them out. New to this Zoom technology like everybody else, so hopefully I can get this done right. Switching back to the first document we're going to go over is the California Advanced Healthcare Directive. California Advanced Healthcare Directive, you may have heard it referred to as a medical power of attorney, living will. Those things all mean the same thing. In California, the statutory form is known as a California Healthcare Directive. And what statutory form means is if you went and looked up the code section, looked up the actual law, this form is there. So all hospitals, doctors, medical providers, they're all used to the same form. The font may be different, but the forms are pretty much the same. If you're a Kaiser member, they have their own form. Lots of the bigger hospital, I want to call them chains, do. But you can also, search on the internet for it. You'll come up with relatively close to the exact same form. So what I'm going to do is walk you through the healthcare directive. I've highlighted a few things that are to note. One is in the instructions here, they tell you if you choose not to limit the authority of your agent will have the right to, and then they list these very broad rights: consent or refuse to consent to care, approve or disapprove diagnostic tests. Basically, your healthcare agent steps in as you to make healthcare decisions for you. But no, you have the right to limit their authority. You also, through this form, can give them some very specific direction. So here's where you designate the agent. You do need to designate just one person. Sometimes that's difficult. Maybe you have two kids and you want to put both kids on there, but think about if they disagree or if one is not available. If that happens, then you basically don't have anybody to make the decision for you. Who's the hospital supposed to listen to? Who's the doctor supposed to listen to? So I and healthcare professionals encourage you to just designate one agent. Trust your kids to talk to each other, or your friends or your parents or whoever it is, that they will talk to each other. But one person in particular makes the decision and executes the documents to carry it out. You can then put an alternate. So if the first person isn't available to act, you're moving on to the second. And if the second person isn't available, you can even put in a third. This section is important. Agent's authority, they're authorized to make all healthcare decisions for you, I highlighted, except as I state here. So if there's something you don't want, you can put that specifically in there. Often put in there is also religious beliefs. Say, for example, that you want to be sure that you're kept alive long enough to have last rites. You could put that in there. Just having your particular religious authority there with you, you could put that in there as well. If you have specific beliefs about blood transfusions, anything like that, you could put that in there as well. This is also a key part. When the agent's authority becomes effective. It is not effective until you lose the capacity to make your own decisions, unless you initial that little box there. Generally, medical personnel are always going to ask you first and have you involved to the extent you can be involved in your healthcare decisions. When you can no longer, or when you initial that box, then your agent will take over. Also important here, agent's post-death authority. Your healthcare agent is the one who can say, who's going to make arrangements for what happens after you pass away, what mortuary your body goes to, whether or not there's an autopsy, to the extent there's a choice on that, if you're being cremated, that sort of thing actually goes to your healthcare agent. A lot of people think it's power of attorney, but it's not. It's your healthcare agent. So you would fill in what your desires were right there in that section 1.5. End of life decisions in section 2.1, this is what people tend to know of as the pull the plug or don't pull a plug. But I would note it's very specific language. There's 3 scenarios where you choice not to prolong life. I do not want my life to be prolonged if 1, I have an incurable and irreversible condition that will result in my death within a relatively short time. And then there's 2 other options there. Or choice 2, prolong life, which is you want them doing everything to the extent possible to keep you going. They have to kind of do it in broad terms like that because it's going to be a different situation for everyone. So the more guidance you can give to your healthcare agent as to what you consider a quality of life would be, the more the better here. Again, these are just forms. I encourage the conversations as well. And then as much as you can put in writing, go ahead and put in writing here. Relief from pain. I direct that treatment for alleviation of pain or discomfort be provided at all times, even if it hastens my death. So there are certain medications and treatments that could hasten your death by hours, days, or even weeks. If that bothers you, then you would change that direction here. But the default is you want alleviation of pain or discomfort. This section 2.3, I highlight in here because in the statutory form, section 2.3 would be blank. It's other wishes and then a bunch of blank lines. So you're able to fill that in yourself. You give whatever guidance you want here in this form. So what I've put in here is some of the things we've come across with clients of ours. So instructions concerning medical evaluations and treatments. My agent is instructed to discuss with me the specifics of any proposed decision regarding my medical care and treatment if I am able to communicate in any manner, however rudimentary, even by blinking my eyes. That's basically saying you want to stay in control for as long as you possibly can. If that's how you feel, that's what you want to put in your directive. Another one here, I want to leave my family, friends, and persons who care about me with assurances of my love and without the burdens of guilt or conflict. My purposes in leaving these instructions are to alleviate uncertainty that otherwise may arise in connection with my decisions about my medical care, to promote family harmony, and to clarify instructions to my healthcare providers. Again, it's kind of a statement of values here. That's not a particularly legal statement, and it's not a medical statement. It's a statement of your values, but it's certainly going to help the person carrying out your directions that you've left in your healthcare directive. Long-term or hospice care, you can put in how you feel about that. If you want, if you want to be maintained in your residence for as long as possible, you can put in directions about that. Medical information and medical records, that's kind of covered more in the HIPAA form as well, but you can expand on it here. We'll talk about the HIPAA form. And then part 3. So again, that section is any specific directions you want. Often that is religious beliefs. It can also be preferences. And it's a good thing to talk about with your doctor when you are diagnosed with something in particular and you have an idea what's ahead of you in treatment. You can kind of put in your specific wishes there. Again, that go to what you consider quality of life or not. Part 3 is entirely optional. It's donation of organs, tissues, and parts at death. This is not a donation of cadaver. I know a lot of people saw or read about I forget what medical school it was, when there was an issue with what was going on with the cadavers, and that scared people off from donating cadavers. That is not what this is. This is strictly organs, tissues, and parts. You can donate them for any of the things listed: transplant therapy, research, or education. If you don't want it, you don't want your organs, tissues, or parts used for one or more, you just cross that out. I do want to point out to you that the default in California used to be if you had not said you wanted to be a donor, you weren't a donor. It's now the opposite. Just because you don't fill this out does not mean you don't want to donate. It means you're leaving it up to your agent. So if you actually don't want to donate, then you have to fill it in down in the blank line. If you want to restrict donations at the top there, then what you would do is say, I do not wish to donate any organs, tissues, or parts. So that, again, totally optional. Part 4, primary physician, also completely optional. A lot of people change primary physicians, or if you're with certain medical groups, they change it for you. But if you are being treated by, say, your oncologist, who you really want to make sure is the person they're consulting, then you would go ahead and list that here. You sign, date, have it either notarized or 2 witnesses. This is an either or. Notary's fine, or 2 witnesses. If you go the 2 witnesses route, one of the witnesses has to sign this additional statement that says that they are not related to you and they're not going to benefit under your estate plan. It's obviously just a safety there. So that's the Advanced Healthcare Directive. As I said, you can Google it or ask your healthcare provider, and you'll probably find pretty much the same form. So I'm going to go to the next document, which is the POLST form. And POLST, where'd it go? Okay, there it is. So POLST stands for, I always have to look at this because I only know the acronym, Physician's Orders for Life-Sustaining Treatment. This is a document that, it's not a legal document, it's a medical document. This is not a document you fill out with your lawyer. This is not a document you fill out on your own. This is a document you fill out with your doctor, and this is the one document where I said everybody over the age of 18 needs to have in place except one. This is the one that's not for everybody. This is for patients who are at risk for a life-threatening clinical event because they have a serious life-limiting medical condition, which may include advanced frailty. So this is a form you should talk to your doctor about. It is normally pink. I think that's so it stands out. It's sort of what they call a portable medical directive, but it is a different document. You need both if you're in this situation. It is a different document than the Advanced Healthcare Directive. Advanced Healthcare Directive is completed by you individually or you with your attorney. This is a document that's completed by you and your doctor. It gives very specific, so it says it right there on the form, this is a medical order, not an advanced directive. For information about POLST and to understand this document, visit www.polst.org/form/. And if this is your situation, I would encourage you to go and to this website and take a look and get the guidance needed. But I'm just going to quickly show you the form. It has to do with CPR and do not resuscitate and types of treatments, including ventilation, defibrillation, intubation, in the news a lot these days. So these things would be decided upon with your doctor, and both you and your doctor, see where I've highlighted there, sign the form. So it has to be completed with your doctor. This is a form you carry with you. It's portable. You carry it with you, or if you're homebound, you may have seen it in people's homes. It's usually pink, and in the days when refrigerators still worked with magnets, you left it on the refrigerator with a magnet, because if EMT ever responded, if paramedics were called to your house, they're not going to be looking for an advanced healthcare directive. They don't deal with advanced healthcare directives. They're going to be looking for this form to know if they're supposed to resuscitate or do any of the things you may have put on this form. So that's the Physician's Order for Life-Sustaining Treatment, nationally known as POLST, and California has adopted this form. Okay, I go to my next form, which is down here. Where did it go? Told you, new to this. Okay, this is the HIPAA form. So HIPAA is the Health Insurance Portability and Accountability Act. This is the federal law, but this is under California law, which matches the federal. So this is for both. What this form is a document where you say, hey, healthcare people, this is who you can talk to, this is who allowed to have information for me, and you list whoever it is. So in this case, this is Jane Smith's HIPAA authorization, and she's authorized John, George, and Martha Smith. You do not have to be related to the people. You can put your friends on here. I wouldn't put a huge list, but you can put your friends, family members, parents, children, whoever it is, and definitely whoever you've named in your Advanced Healthcare Directive, you should be naming on this HIPAA form as well. You're giving them the authority to get information. They don't have any authority to act by virtue of this document, but they do have the authority to receive information about your health. In our form, we also include as people who are authorized to get this, the trustee, get information, the trustee or successor trustee of any trust you may have. We'll talk about trust briefly at the end, and your attorney for limited purposes of determining your capacity. Those might be important people who need this for those very reasons. Authorization is not affected by and shall not terminate by reason of my subsequent disability or incapacity. This authorization shall terminate 1 year following my death. That's important to know. Often they do need, particularly if there's any sort of lawsuit or anything going on, they do need access to your medical records. Power of attorney, which we'll talk about in a bit, expires at your death. This can continue on where they can get some information for a year after. It's a general form. Like I said, you could search for this and you would find a very similar form. Your hospital or doctor probably has one as well. Usually they ask you for it the moment you show up, especially at a hospital. You sign, there we go, you sign with your date of birth, and again, it needs to be notarized. This one doesn't work with witnesses. The federal form, and they want it notarized, so you have to have a notary for this one. Okay, can I go to the next document we're going to talk about? And I know I'm kind of flying through these. I kind of have to. I only have 25 minutes with you, or thereabouts. So the next document we're going to go to, do not make this easy. Where am I? Sorry. Okay, we were on 3. Is a general durable power of attorney. Actually, sorry, I have to go back. I have to go back one. I need to go. There we go. There it is. Okay, sorry about that. A statutory form power of attorney. So a power of attorney is a document that says if you're incapacitated or if you've agreed to let somebody take over, this is who can take over and act on your behalf with respect to certain broad legal categories. Once again, in California, it is a statutory form, which means California has come up with the very specific language, and you can find this form again on the internet and use it. Not a huge fan of it, but something is better than nothing. So I want to walk you through this kind of quickly, because then I'll show you a better power of attorney, which is my power of attorney, or a power of attorney that is crafted more specifically to your needs. But this is the general one that works in a pinch. Your name, and you appoint whoever it is that you appoint. And then you grant the following powers. So you can check the boxes for what types of powers. You can see A through M there. They're pretty broad powers. Or you can simply just initial N, and then you've given all of those powers to whoever it was you named. You can give special instructions limiting or extending the powers, and you may really need to, because those are very broad powers, and sometimes you need very specific powers. One of the things I don't like about the form is it makes it difficult for you to say this person, and if not that person, then this person, and if not that person, then this person. Although they did stick this little line in here, if I have designated more than one agent, the agents are to act, and you're supposed to fill in either separately or jointly. But if it's separately, it's hard to tell what the order is, and if it's jointly and you've named 4 people, it's going to be a mess. It's one of the reasons I'm not crazy about this form. Then you sign the document, and once again, you need to have it notarized. Now on this document, also 2 witnesses would work. It's just the standard form doesn't usually come with the witness language there for you, so you're gonna end up defaulting to the notary. Okay, I have to do this one more time. You'd think I'd get really good at this. So now I'm going to the 5th document, which is the general power, durable power of attorney. So this is my version of that statutory form. So they're the same. They're meant to do the same thing. It's just that we've really expanded it. So I have expanded it so that you can say who an initial agent is, and then if they can't serve, who the next in line is, and you can keep going after that. And no one under 21 can serve. it's a big job. You don't want someone under 21 doing it. This says also how it becomes effective. You can either sign saying, yep, it's effective now, or it's two physicians declaring you incapacitated, or a court, or you disappear or are detained for 30 days. Power of attorney expires at the earliest of my death or when you revoke the power of attorney. Important to know that, because I've seen time and time again where there's an elderly parent, is usually the circumstance, and they give power of attorney to a child, an adult child obviously, who's then helping to pay all their bills and taking care of things. But when mom or dad passes away, so does the power of attorney. So the child goes in to, you know, take over the bank account or empty the bank account or whatever the case is, and they can't access it anymore because the power of attorney is no longer valid. Power of attorney stops with your death. They can't do more than you can do. And when you've passed on, you can't do anything, and neither can your agent. So that's important to know. I'm gonna go through this a little quickly, but you can see that we've really expanded the powers. And the reason for that is because when your agent needs to use the power of attorney, whoever the third party is that they're handing it to usually wants to see pretty specifically that what you're trying to do is authorized by your power of attorney. Power to manage digital assets, your statutory form, because it's old when they created it, doesn't include this. So any domain names, videos, digital photographs, anything, software licenses, your power of attorney will need to have this specifically in there. Oil, gas, and mineral interests, operating your business, if that applies. There's lots of power regarding governmental benefits. So lots of things where this has become, it's a 29-page form, mostly because we're adding powers to do just about anything you could imagine. Powers regarding taxes, powers regarding your spouse, powers regarding making gifts, care and control over you, power to provide for religious and spiritual needs, power to provide for companionship. You can see it's pretty detailed. Power regarding your mail, very important. And I love this one because I'm a huge animal lover, power to care for my pets. That can be very important. If you use the statutory form, you can handwrite in some of those specific powers, but as you can see, that gets a little wordy after a while. So that's a durable power of attorney. Again, something anybody should have in place. Once you turn 18, your parents are no longer authorized to take care of things for you. It's you. So you're going to want to have those in place. Sorry, I can stop paying attention to the techie stuff now and just pay attention to you. So those are the basic documents: healthcare directive, HIPAA form, power of attorney, and then a POLST form. That's the physician one. If you're in a serious medical situation, life limiting as they call it, that's one you're going to want to go over with your physician. But I will also talk to you for a brief moment about wills and trusts, because those are important. The documents we just talked about are documents that affect you when you're alive. So does a trust, however. A trust can be, you put a trust in place and you transfer title to your assets into it, and then the living trust says, here's what happens if I become incapacitated, and here's what happens if I die. Both who takes over and what happens to your assets. And in the event of incapacity, it's also what happens to your assets and what your priorities are and how they're to take care of you versus anybody dependent on you, that sort of thing. You cover it all in a trust. And in California, if you have assets that exceed, it's some weird number now, but it's like $162,000. It's not high. It's $162,000 of assets, and that's gross assets. Then you're going to end up, your estate is going to end up in probate court. Now, note I said gross assets. So you could have a home worth $200,000 and you have a mortgage of $190,000 against it. I don't know how you did that, but you did. That's a gross estate of $200,000, and that's going to have to go through probate in order to be transferred on to your heirs. On the other hand, if you had a trust in place and title to the home was held in the trust, there wouldn't be any probate. We would just follow the trust and do what the trust says. So it's a handy thing to have. It's private. It is less expensive. I know they're not cheap, but they are less expensive than probate. And it can handle both your incapacity and your death. And then everyone needs a will. Even if you have a trust, you still need a will in place. And the will, if you have a trust, the will just says, okay, if I forgot something, put it in my trust and do what my trust says. If you don't have a trust, then your will at least says who's going to carry out things for you, who's going to handle the probate, and who's in charge of transferring assets, whether it's through probate or any other kind of, there are other kinds of proceedings that can happen depending on if there's a surviving spouse and things like that. So that's, and again, because we never know what's out there, any adult 18 and older needs to have a will in place, needs to have a healthcare directive, power of attorney, HIPAA form. If you have assets over the 160,000 that aren't being transferred through joint tenancy or a beneficiary designation like life insurance or retirement plans, then you're going to need a trust as well because it's California. I often joke that California has a lot of lawyers and they try to keep us all employed. But in this case, you'd be employing and paying a lot more to an attorney to take your estate through probate than you would be by simply going through a trust. So that is my very quick rundown of all of the documents you need to have in place and should consider. Gave you the information to sort of help yourself where you can, because again, I believe something's better than nothing. I also want to mention just very briefly, California does have an end-of-life option. The California End-of-Life Option Act went into effect in June of 2016. The act allows certain terminally ill adults to request and obtain a prescription for medication to end their lives in a peaceful manner. The act outlines the process of obtaining the medication, including safeguards that protect both the patients and the physicians. So if that's something of interest to you, I would simply say take a look at the California deathwithdignity.org. And you can find out a lot more information there. It's definitely something to be talking about with a physician. In fact, you have to. So with that, I would say thank you for listening in. I hope you found some valuable information. And again, try to think of this as a way of sharing your beliefs and your values with your family members and loved ones, and giving them the gift of knowing that they're doing what you would have wanted them to do, and helping them through what might be a very difficult time as well. And I think having these conversations ahead of time will probably bring you some peace of mind as well. So with that, thank you very much. I'm Teresa Ryan, and take care.